The Federal Firearm Rights Restoration System is being built right now. We are pulling from Department of Justice framing papers, technical architecture specifications, and federal statutes to map out exactly what this infrastructure looks like.
Yeah, we are detailing how it will judge applicants, how it processes subjective data, and why the cross-jurisdictional data puzzle requires such massive engineering.
Because the United States Department of Justice is actively developing the operational infrastructure for the Federal Firearm Rights Restoration Program under 18 U.S.C. Section 925C.
And the Office of the Pardon Attorney will administer the program.
The federal government is constructing a comprehensive digital and administrative pipeline. I mean, this is a complete federal intake, investigation, records management, and application review system.
Building a platform capable of processing federal relief applications requires a massive architectural lift. It requires far more than a simple online form.
Got it. And the infrastructure is currently being built. The public application portal is not yet accepting applications.
Yeah, the immediate operational focus is on constructing the mechanical systems necessary to ingest, secure, and evaluate complex legal histories.
So a web-based intake system is being developed to receive applications directly from individuals seeking restoration of their federal firearm rights.
The front-end architecture must handle direct interactions with applicants across the country. It requires secure portals for document uploading, identity verification, and status tracking.
An applicant will not simply mail a paper packet to Washington.
No, the intake system will collect personal identifying information and criminal history information. It will also ingest court records, conviction documents, personal statements, references, character evidence, rehabilitation evidence, and, other supporting materials.
Wow, every applicant will submit a massive volume of data.
Yeah, the system must process both structured data like dates and conviction codes and unstructured data like multi-page personal statements.
Wait, an applicant uploads 50 pages of highly sensitive court and medical records. Where does that actually go?
Well, a standard cloud server is not legally cleared for sealed criminal records. The technical weight of this requirement is massive.
Okay, so what prevents a catastrophic data breach of millions of federal relief applications?
A new electronic records database, officially identified as the Federal Firearms Rights Restoration Electronic Records Database, is being put in place. This back-end infrastructure receives the data from the web portal.
I see.
The electronic records database is the foundational core required to securely house these files long-term while reviewers access them.
Because building a system to receive, store, organize, secure, and manage such highly sensitive legal and personal documents requires military-grade data security protocols.
Yeah, federal law dictates strict security parameters for storing personally identifiable information and sealed criminal records. The system cannot rely on standard commercial data practices.
So the Department of Justice is engineering this database to comply with federal data protection standards.
The architecture must encrypt data both in transit and at rest. It must prevent unauthorized external access while allowing simultaneous secure retrieval by authorized personnel within the Office of the Pardon Attorney.
And access logs must track every internal interaction with an applicant's file.
Yeah. Once that data is secure, a digital case management system will track each application.
The software moves the file systematically through multiple stages: intake, document collection, records verification, investigation, individualized review, and a final recommendation or decision.
It acts as an automated traffic controller. It routes the applicant's file from an initial intake clerk, checking for document completeness, directly to a specialized investigator evaluating character evidence.
So the case management software structures the entire evaluation.
Yeah, it forces reviewers within the Office of the Pardon Attorney to assess the applicant against specific statutory criteria.
Reviewers will examine an applicant's criminal history, record, reputation, conduct, character, and possible public safety risk.
Software workflows mandate that no statutory requirement is skipped during the evaluation phase.
But how does a digital system evaluate subjective human elements like reputation and character? Processing an abstract concept like human rehabilitation requires a different mechanical approach than organizing binary data like felony conviction codes.
Well, it relies on concrete, submitted evidence.
Okay, what is the actual verification mechanism for subjective documents?
Yeah.
How does the system know that character references aren't just fake letters written by the applicant's friends?
The database allows reviewers to cross-reference the applicant's required personal statements, character references, and rehabilitation evidence to make comprehensive assessments.
They look for corroboration.
Yeah. The system links a submitted character reference directly to verified employment records, financial stability indicators, and a clean background check. A single character letter carries little weight without verified supporting data.
Think of this case management system like a credit scoring algorithm, but for human rehabilitation. A financial algorithm takes disparate behaviors, missed payments, credit utilization, account age, and flattens them into a quantifiable credit score.
And this software system must take decades of subjective behaviors, employment history, community references, clean police records, and flatten them into a single quantifiable profile of public safety risk.
The subjective becomes objective through volume and verification.
Yeah, the case management software creates a unified profile of the applicant's current conduct. The Office of the Pardon Attorney then uses this compiled profile to prepare recommendations for the Attorney General or the Attorney General's designee.
So reviewers draft formal evaluations detailing whether the circumstances regarding the disability and the applicant's record and reputation demonstrate that the applicant will not act in a manner dangerous to public safety.
They also evaluate whether granting relief aligns with the public interest. The entire process hinges on data fidelity.
The internal federal database must connect with external agencies to verify the documents submitted during the intake phase. The Office of the Pardon Attorney may coordinate with federal, state, local, and tribal authorities to request, obtain, confirm, and review relevant legal records.
The system cannot rely solely on applicant-provided files. It must process diverse legal documents.
Reviewers will examine felony convictions and misdemeanor domestic violence convictions. They will also process controlled substance findings, involuntary commitment orders, and protective orders.
Each category of document originates from a different type of court or medical board. State courts use different coding systems for criminal offenses. County courts have distinct data retention policies.
So the federal system must seamlessly ingest and standardize records from hundreds of independent jurisdictions.
The database architecture must map diverse local codes to the uniform federal prohibition criteria under 18 U.S.C. Section 922G.
Essentially, the federal master list of what legally disqualifies someone from owning a firearm.
Yeah, the case management system relies on specialized data sharing agreements to pull authoritative records from state repositories.
But how does the federal government resolve a local county's obscure misdemeanor code from 1998 into a federal binary prohibition today? This creates immense logistical friction.
Some counties digitize everything. Other jurisdictions rely on paper archives. The federal system must establish common data pathways across all of them.
And the data integration challenge expands significantly when coordinating with tribal authorities.
The Department of Justice released a specific framing paper to address these data integration challenges. This document supports government-to-government consultation with tribal leaders regarding how tribal records will be collected and managed.
Because tribal courts operate as independent sovereigns. They generate protective orders, commitment orders, and firearm possession prohibitions under tribal law.
The federal database cannot simply extract data from sovereign systems. The federal government cannot issue a standard subpoena to a sovereign tribal nation and demand database access.
It requires structured, negotiated data pipelines.
Yeah, the Department of Justice is asking tribal leaders if all records received from tribal authorities should be treated alike. They are seeking input on the specific steps the federal government must take when requesting and storing these documents.
They must determine how tribal legal codes align with federal statutory definitions.
This detailed implementation work is required to ensure the federal records verification process is complete, dependable, and capable of operating across different jurisdictions.
The federal government is addressing the mechanics of cross-jurisdictional data verification. They are establishing procedures for handling correspondence with tribal courts.
They are defining how copies of actual tribal court orders become integrated into the federal records set within the Federal Firearms Rights Restoration Electronic Records database.
This consultation process dictates how the back-end software will actually function.
If a tribal court issues a protective order, the federal case management software must possess the specific fields necessary to ingest that sovereign document, verify its authenticity, and weigh it against the federal criteria for relief.
This matters to you because if a state or tribal court's retention policy wipe your disposition records, and this federal database cannot verify your submission, the system is designed to flag that discrepancy.
That is where applications will stall. The burden of proof remains on the applicant to provide authenticated records when the federal data pipeline encounters a blind spot.
The system design ensures that the comprehensive review phase relies strictly on verified data.
If an applicant submits a state court disposition, the Office of the Pardon Attorney utilizes established agency coordination protocols to confirm the authenticity of that document.
The case management system flags discrepancies between applicant-provided files and official state, local, or tribal records.
Reviewers must halt the evaluation phase until those discrepancies are resolved.
So the entire operational design focuses on evidence-based evaluation. The digital infrastructure supports a rigorous investigative process.
It provides reviewers with the software tools necessary to analyze the whole person, evaluating decades of conduct following a prohibiting event.
The system forces reviewers to weigh recent conduct heavily while analyzing historical patterns.
The infrastructure mandates a structured, standardized review of highly complex individual histories.
The Office of the Pardon Attorney is building the administrative capacity, staffing models, and software systems necessary to process applications securely and efficiently.
Software alone cannot restore rights. The federal government must train dedicated personnel to operate the digital case management system.
The practical systems required for the federal restoration program to function are taking shape, but the system is not yet live.
Do not wait until the application system opens to start preparing.
Go to fedgunrights.com and use the 2A eligibility tool to find out whether you may qualify.
Get the 925C Made Simple workbook at legal-gangsta.com/shop-1 to begin organizing your records and building your application preparation packet.
Go to fedgunalert.com to receive an alert when the federal application system officially goes live. The infrastructure is being built. The time to prepare is now.